Hi, I'm Jessa and I'm currently studying towards my RICS chartership in quantity surveying and construction. Today I'm doing a quick overview of the RICS Conflicts of Interest document, which falls in the competency for ethics, rules of conduct and professionalism. In particular, I'll do a summary of the document, then go into more detail about the types of conflict and the measures that can be put in place as per the document. As always, you can find my timestamps, sources and a link to some example questions in the description below. This document is a professional statement, which means it's a mandatory requirement for RICS members and regulated firms to follow. It took effect from the 1st of January 2018 and is split into 3 parts. Part 1 sets out the definitions and mandatory rules on conflicts of interest and confidentiality, and the other 2 sections provide commentary as guidance on how members and firms can meet the obligations in Part 1. The main reason for needing to avoid conflicts of interest is to make sure there's nothing in the way of our professional duty to advise and act for our clients objectively without impacting other clients, third parties, or our own interests. This helps maintain our integrity and maintain public confidence in the profession, as per the rules of conduct. There are 3 types listed: party conflict, own interest conflict, and confidential information conflict. If there is the potential for a conflict, we need to obtain informed consent from our clients, or consider saying no to this work if it means we cannot fully act in our client's best interests. If there is the chance that we might need to share confidential information from a client, say to inform professional indemnity insurers, this needs to be set out in our documents of appointment from the client for avoidance of any doubt. The appropriate systems will depend on the situation, but could include an information barrier that means people in the same organisation are physically and/or electronically separate and don't have access to each other's job files. Within our firms as RICS members, we have to record our decisions and monitor the process and outcomes in case it gets audited or investigated later. That covers the document very briefly. Now I'll go into the types of conflicts. Party conflict. This is if an RICS firm or member might be acting for a client that has conflicting interests with another client, say if you are acting on behalf of 2 businesses with the same interests, like competing supermarkets. The next is the own interest conflict, where a member or firm's personal interests conflict with their clients, such as financial or commercial interests or personal relationships. This could also arise with a success-based payment agreement between the client and the surveyor. Own interest conflicts often carry greater risk, and it needs to be ensured that nobody's financial and personal interests are being harmed. Finally, there's confidential information conflict, where the obligation to provide information to one client might conflict with another client's requirements to keep that same information confidential. Confidential information is information that's considered to be held private, whether that's electronically, verbally, or physically. Members and firms are required to maintain the confidentiality of this information unless it is required by law to disclose, or if the relevant party consents to it being disclosed. The duty of confidentiality is continuous and ongoing, so it applies to previous, current, and potential future clients. The nature and extent of the information held for other clients will help determine whether it's possible to act for a new client. Sometimes information needs to be disclosed to insurers, and it's currently uncertain in English law whether regulated firms are entitled to pass confidential information to their PI insurers or to external legal advisors. This puts members and firms at risk of breaching their obligations to their insurers, so the RICS's solution is to put in the terms of engagement with the clients that the firm can pass confidential information to professional indemnity insurers and legal advisors. Now I'll move on to measures within firms. All RICS regulated firms worldwide have to have measures in place to ensure compliance with this professional statement. This also applies if an RICS member is not in a regulated firm. This includes keeping records of any decisions made and measures taken, then monitoring these when obtaining informed consent. Informed consent is consent that is willingly given by someone who may be affected by a conflict of interest. The client would need full understanding of what this conflict is, what the risks are, the known and relevant facts, and they must accept that this conflict may well affect the professional's ability to fully act in their best interests. There's an appendix at the end of the document which contains a sample form for obtaining informed consent, which is a suggestion and should be considered and amended depending on the situation. The level of information provided to the client could also vary depending on the situation. If they are a large entity with lots of experience in this sort of thing, you may not need to provide as much detail, but for individuals or those rarely employing construction professionals, they may require more information. If you don't believe the party has sufficient understanding, they can obtain independent professional advice from, say, a lawyer, or the instruction should be declined. Also, if it isn't possible to tell the client enough information about the competing interest due to confidentiality, you also should not proceed. If this were the case, the client's informed consent might be inadequate to manage a party conflict. Sometimes conflicts of interests can come after we've been appointed as professionals for a client, so the status of professional conflicts needs to be monitored throughout our duties as well as from the outset. If a new conflict of interest arises, we would need to obtain informed consent before proceeding with duties that could cause a conflict of interest. Even if a client is willing to give informed consent, it doesn't mean that they have to proceed. This is dependent on different circumstances. The member or firm must exercise their professional judgment and determine if we can represent the client objectively and without bias. We could also consider recommending another colleague or organisation to undertake these duties to the client in order to maintain public confidence in the profession. One system within firms includes an information barrier, which is the physical and/or electronic separation of those within the same firm to prevent confidential information passing between them. If there is an information barrier already in place, the client will still need to provide informed consent unless it's specifically protecting confidential information to a person that is no longer a client. The onus is on the firm to make sure the systems to prevent this information being transferred are effective and being monitored appropriately. They may need to consider the logistics of where people sit in offices, access to different emails and file stores. If the firm is closely related to another company, such as a parent company, there is also an increased risk of a conflict of interest. This can be mitigated and considered unlikely if the firms are two completely separate legal entities, if there are no employees in common between them, or if there is no fee sharing or information sharing relating to the area of conflict too. All decisions, actions, and communications should be kept in case they are audited or they are required for investigations later. This means if there are discussions that happen verbally, they need to be confirmed in writing as soon as reasonably possible. The appropriate systems will vary depending on external market factors, the size and complexity of the firm's structure, if and when the firm changes and evolves, and the number of areas of practice that the firm provides. If a firm is multidisciplinary, say providing both quantity surveying and project management services, they need to monitor the different services being provided for a particular client and make sure there are no conflicts here as well. Thanks for watching this video. I'll probably do a quick summary of different professional statements and guidance notes that I feel like I need to know for my final interview. If you have any questions, requests, or anything else to add, please leave a comment or contact me on my social media in the description. That's all I have to say for now. I hope it helped build on your mind.